Greetings to you. Hello, this is Courtney Rollins back here with another edition of Life in Transitions Experts podcast. If you're new to this channel, welcome. You may be here because you are experiencing a probate, or you're going through some transition where you have to sell the affairs of the estate of someone, or perhaps you're trying to figure out what to do with property or with the personal items in place as you attempt to move. Maybe your mom or your dad, or maybe you're thinking about moving into a different community. At Life and Transitions Experts, we really try to help folks through those transitions. And if you're on the YouTube channel, we'd love for you to hit like and subscribe. If you have any questions or anything that I can try to address, I'll do my best to do so. I am not an attorney or a CPA or financial advisor or giving legal advice, but I do consider myself a probate specialist, an expert, and that requires and takes an approach of learning and sharing. So that's the reason I'm sharing here today. And actually, I'm going to share a question that just came up. Someone saw some of the videos. Really nice young lady. Her and her husband are going through a probate now, and she had a question about how to distribute some of the assets that are in the estate. However, the estate does not have a will. So let's take a look at what that is, and hopefully this will be able to answer some questions for you that you might have had as well. And so let's go. So I'll add that. It's easy peasy and present. All right, my dad wanted my brother to get the car, but there's no will. So this may happen in a lot of ways. You know what your mom or your dad or someone wanted these properties to go to, but for whatever reason, they were not able to put this into writing in a will or in a trust. And so now it's up for the state to determine how things are distributed. And just a reminder, when someone passes away testate, that means they passed away with a testimony. Testate, their last will and testimony of what they want done. That's called passing away or dying intestate. So if a decedent leaves a valid will behind, they've died intestate. But if someone dies or passes away intestate without a will, then it's called intestate. And the difference is now the probate will be administrated as opposed to the will being executed. That's why the person who's the personal representative of a person within who passed away testate is called an executor, because they're executing the will, the wishes of the last will and testament. If it's intestate, that's a letter of administration. They're administrating. Same level of responsibility, but different name based on how the estate is settled and how the person passed away. So in North Carolina, intestate law says that a person without a will, the property can be divided between the surviving spouses and children, or spouses and parents if there aren't any children. And it all depends on the value of the property. You can go to nccourts.gov and they have full, chart or range of how things are distributed based on who survived and who hasn't survived. Okay. And some people may not be aware of this, but there are probate assets and there's non-probate assets that people pass away in North Carolina. Quite often real property, which is houses, are considered real property. They're considered non-probate assets. Quite often you don't have to go through probate unless you're looking to sell it, or unless you're looking to pay off debts and things of that nature. There are situations where you may want to go ahead and probate it, may need to go ahead and probate it, but for the most part, it'll just transition into the based on intestate laws if there is not a will. Real property or personal property, such as cars, houses, guns, and things of that nature, those will have to be accounted for definitely in the probate process. So again, that's just a disclaimer. I'm not an attorney or a financial advisor, but we're going to look at 5 things to think about when there is no will. That's notice to creditors, an heir affidavit, renunciation of beneficiary, receipt of the beneficiary, and transferring title. So notice to creditors. This is a part of the probate process that after you open up probate, you're going to go to a qualified publication and place in there for 4 weeks straight that there is an estate open. If you're a creditor, you need to come and raise your hand and say, hey, this is owed to us. After that 4 weeks, all creditors will have an additional 3 months, 90 days to share whatever they're going to share, or to stand up and say, hey, please, let's make note of this and let's address this. Now, just a little side note, please do not just start paying. If you're the administrator, don't start paying all those bills until notice to creditors period has finalized. One, you may be able to negotiate some of those down. And two, there are priorities. So you don't want to pay off something that wasn't supposed to be paid off as opposed to something of a higher priority. So let's wait till the notice to creditors is run. You get the affidavit that, hey, notice creditors has run, fulfilled obligation there. Then you can decide and determine how to address those creditors based on what's in the estate. When there is no will, there's an heir affidavit that you'll need to fill out. It's pretty standard. This is quite often you'll have to fill this out if you're trying to either transfer, if you're trying to sell a property or you're trying to transfer a title or deed. Quite often, closing attorneys in North Carolina will ask for this, and this is just a generic one. It's basically saying you'll find someone, third party, who knows you and the decedent and can verify that this person passed away, that this person left behind these folks or didn't leave behind these folks, and you'll be able to get that notarized, and that should be good to go. And you'll also need a renunciation of beneficiaries if there's more folks, particularly in this situation. There were several brothers, but they all knew that the father wanted one of the brothers to have the property. So the other brothers or the siblings will had to fill out a renunciation of beneficiary. You could pull that online or go to my website or DM me and I'll send it to you, or click on estateproservice.com to check out these. But these are all public documents that you can get just through a Google search. So you make sure you have that in the file so they know, okay, they're not, and you can specifically state what you're renouncing your benefits from. So if you want to keep partial credit of a house or some other thing, but you don't want anything to do with the motorcycle, then that's what you'll make a note of, and you'll just write it out right there for the renunciation of beneficiaries. Also, make sure that after you've paid off the debts and you get the renunciation, whoever you do send it to, whoever receives assets, make sure you have a receipt of beneficiaries that will also go into the probate file. Transfer taxes can be very different. Again, if it's a non-probate asset like a house, the closing attorney may want the affidavit, the heir affidavit, and you'll go through the closing process, transfer taxes, things of that nature. If it's something like a motor vehicle or even a mobile home that may be designated as a motor vehicle, it's a matter of taking the title, taking the deed, and notarizing it over to the estate, the administrator, notarizing it over to whoever they want it notarized to, and make sure you get a receipt of beneficiaries and things and make sure you get that done. And and if you do need the title or the deed, then you can, with your letter of administration that you receive, showing that you have authority to administer the estate, you can request the title. If you need any support or help with your estate work, check us out at Estate Pro Service. We have a workshop that's taking place every Wednesday at 12 o'clock. It's really me just going over the basics of probate and answering any questions folks may have. We'll love to see you there and love to help you out. I know this may be a challenging time, but you've made the big step in already doing what you need to do to make sure that you've adhered to the laws of North Carolina and taking care of I'm assuming that loved one who's passed away, taking care of their estate. All right. So other than that, folks, I am going to sign off as I always do, saying, life and transitions experts, let your light shine. Cheers.